All right, we're going to open the meeting initially with comments, actually an overview from our attorney describing the plan and the process here.
Thank you, Mr. Chairman. Welcome to tonight's hearing. This is a very unique kind of a hearing, so you're going to hear a few comments from me along the way as we get started with this to kind of orient you to what is an unusual statutory kind of hearing. First, there are two related matters on the agenda tonight. First is the consideration of the boundaries of a potential redevelopment area. And then there will be a public hearing, as we're now into, on the redevelopment plan itself. These matters provide the groundwork for the redevelopment project, because if a redevelopment plan is approved and the village board declares an area to be a blighted area, the Community Development Authority may then exercise the powers granted to it by statute for the acquisition and assembly of the real property of the area under section 66.1333 sub 6 sub c. Such a decision has another effect as well, because if such a decision is made, it will provide the groundwork for the CDA to be able to issue double tax exempt bonds to finance the project. For those of you who are not familiar with the phrase double tax exempt bonds, it means that the bonds are not taxable under either federal or state law. And when that happens, the bonds can be sold at a lower cost for interest because people will not be paying federal or state taxes on the bond receipts, interest, for example. My plan is to give you a little background on this matter and then turn it over to Sam Schultz, who will review the actual plan itself. And then we'll be listening to public comment on matters related to the contents of the plan. Although the CDA will take action on the boundaries tonight to simply say these are the boundaries of the area that we're considering, that is all that will be done tonight. Because the statute, as I referred to before, is unique. And I'm going to quote the statute to you because of its unique character. And I'm reading 66.1333 sub 6 sub b sub 3, and this is a direct quote. Any owner of property included within the boundaries of the redevelopment plan who objects to the plan shall state the owner's objections and the reasons for objecting in writing and file the document with the authority before the public hearing, at the time of the public hearing, or within 15 days after the hearing. The owner shall state his or her mailing address and sign his or her name. End of quote. Now what that means and what makes this unique is that the statute does not seem to pay a great deal of attention to what people have to say at the public hearing as compared to what they might write and submit as part of the record. I can assure you that this board will consider everything that's said here tonight as well as everything that comes in written form. But the most important and significant part of this is that while the public hearing closes when public comment is over this evening, there is a 15-day period during which you or any owner can submit something in writing. What that means is, although the public comment period is over, the matter is not fully submitted until 15 days goes by. And that is why no decision, no indication of where anybody is thinking about this will be made tonight. That will not occur until the CDA has its next meeting, which has to be more than 15 days in the future. And I will tell you that the CDA has already scheduled its regular April meeting for April 17th at 5 o'clock in the afternoon. And we expect that at that regular meeting of the CDA, which will be on April 17th, the board would be taking up all of the information that has been accumulated either through the public comments or through written submissions made before, during, or in the next 15 days. What I want people to understand is that the 15-day period is statutory. So I don't want anyone to be misled that because the CDA will not meet until April 17th, that they have until April 17th to submit additional written material. My suggestion to you is if you want your submission to be counted and reviewed and evaluated by the board, you should file it within the next 15 days. Don't wait until the last minute and then have someone say, well, you filed it too late, so it won't be considered. Once the CDA takes action on this on April 17th, it will forward its actions to the village board. This board does not have final authority on any of these issues. It only has authority to set the boundaries and to receive all of this information that deals with the plan itself. So the village board will eventually consider, if it gets to the village board, the boundaries of the area, whether the area meets the definition of a blighted area, whether to approve the redevelopment plan. If it gets to that particular point, each of those matters has to be the subject of a separate motion for the board, and in order to be approved, it requires a 2/3 vote of the village board. And for you Mount Pleasant folks who have been living with a 6-member board, village board for the last couple of years, you will now have 7 because the election on April the 3rd will result in there being 7 members of the village board. So if you do the math quickly, you will note that nothing can be approved by the village board unless it has at least 5 of the 7 votes, because that's what it takes to get to the 2/3 or more. Some questions have been raised earlier, so I want to comment briefly on them. The village is acting under its statutory powers under 66-1333 sub 6 and 66-13.39. This is the part of the statutes that gives villages the same powers as cities. The CDA's authority to act is under 66.1335, which statute specifically provides that the CDA has the authority to act under 66-1333, and I quote, "The Community Development Authority has all powers, duties, and functions set out in sections 66-1201 through 66-1333 for housing and redevelopment authorities." Now, there's been a lot of conversation about what is a blighted area. So I want to make it very clear to you that there are 3 statutory definitions of what is a blighted area. And the one that the board is considering is set forth in subsection 3 of 66-1333 subsection 2M, and I'm going to quote it for you. Quote, "An area which is predominantly open and which, because of obsolete platting, diversity of ownership, deterioration of structures or of site improvements, or otherwise, substantially impairs or arrests the sound growth of the community." Unquote. And that is the provision that the board will be considering. They're not considering subsection 1 or subsection 2, it is only subsection 3. A little history for you who are interested. The question of the constitutionality of the Wisconsin Urban Renewal Law was decided by the state Supreme Court back in 1954 in a case that came up out of the city of Milwaukee called David Jeffrey Company versus Milwaukee. As early as 1976, the Wisconsin Attorney General filed an official opinion advising that non-blighted property within a blighted area can be acquired under municipal eminent domain power. That's in volume 65 of the opinions of the Attorney General at page 116. And in 1996, the Wisconsin Court of Appeals directly addressed the question whether a municipality may use its eminent domain power to acquire a non-blighted property which is located within a blighted area and which is necessary for a project. The decision in Grunwald versus Community Development Authority of the City of West Allis was decided in 1996, 202 Wisconsin 2nd 471. It was clear and unanimous in its holding that such a property could be acquired by eminent domain. The court held the statute allows municipalities to condemn vacant land and sound conforming buildings that are located in a blighted area. The court noted that this statute specifically grants authority to condemn property located in a blighted area, and the authority includes property which is not itself blighted. The Supreme Court later denied a petition to review that decision, and that decision was published and became the law of the state of Wisconsin. So I want to clear up a misconception that some people have expressed to me, that the property that they own is not blighted property. That may very well be true. But based on what I've provided to you above, even though there may not be a single blighted property within the boundaries of the redevelopment area, the area may still meet the definition of a blighted area, which allows the acquisition of non-blighted properties. The area we're talking about here contains about 2,815 acres of land in 130 different parcels of property. The village already owns, or will own within the next week, approximately 2/3 of the land required for the project within the boundaries. For those of you who like numbers, the 2017 assessed value of all of the real estate in the entire redevelopment area of over 2,800 acres was $17,211,900, which equates to an equalized value of $17,791,917. The estimated value of the first phase plant area to be built in the Foxconn development will add approximately $1,400,000,000 to that number. For those of you who like to compare what was to what might be, the multiplier here is a little bit more than 82 times the current value of the property. A few other people have asked for my comments because we've been talking to a number of people about tax treatment of property that's acquired either by eminent domain or in lieu of condemnation. And a lot of people have heard me say before that they need to consult with their own attorney or their accountant about what is called Section 1033 of the Internal Revenue Code. That section of the law permits people whose property is acquired by eminent domain or in lieu of condemnation to reinvest the proceeds that they receive within more than a 3-year period, because the time begins at the end of the year in which the transaction takes place, plus 3 years. And if the money is properly reinvested, there is no tax that is to be paid on the gain. The gain is postponed. And if it's well planned, it usually results in no taxes ever having to be paid on that particular matter. Again, it's not my function to give individual advice to people, but the only advice I would give you is if that is a matter of interest or concern to you, you definitely should be consulting with a professional who deals with that particular subject matter. And I note that there are a number of professionals around the room tonight who probably don't have enough to do, and so you might want to consult with one of them or someone else of your choice. I'd now like to turn it back, Mr. Chairman, so that Sam has an opportunity to take people through this comprehensive plan, which has been on file here at the Village Hall for approximately a month now, and people have had full access to it, and all members of the CDA have copies. Thank you.
Before Sam speaks, does anybody on the CDA and only CDA have any questions for Attorney Markuvitz? Yes, Frank?
For clarification, your 15 days, is that business days or calendar days?
Well, you know, what I always do when I read a statute is I read it the most conservative way. It does not say 15 business days, so I would assume to be on the safe side, it should be 15 calendar days. So the statute book does not count today. Tomorrow would be day one. So if you go to tomorrow as day one and count up to 15, that day would be the last day in which you could submit that written material. My suggestion to you is that you either mail or bring it to Sam Schultz, who's the Executive Director of the Community Development Authority, address it to him here at Village Hall or bring it to him at Village Hall. Everything that you bring to him during the next 15 days or file tonight as part of your comments and submission tonight will be copied for each member of the board, and you will learn what the board's reaction is to it at the meeting on April 17th.
And the date would be April 4th, would be the 15 days.
Thank you.
Any other questions from the CDA? All right, Sam?